Welcome, everybody. Good afternoon, and welcome back to the Disability and Rights under Neoliberalism conference. This afternoon, I'd like to welcome you all to our last keynote session of the conference, where we will have both Professor Peter Bartlett and Professor Anna Lawson speaking for this keynote session. My name is Emily Kakoulis. I'll be chairing the session. I'm a member of the SLSA and of this organising committee for the conference. A short description of me: I'm a woman with olive skin, dark hair with white streaks, and I'm wearing a pink top. So first of all, I'm absolutely delighted to be introducing our two speakers for this session. So firstly, I'll introduce them, then I'll run through quickly the structure of our session and a little bit of housekeeping, and then I'll hand over to our two speakers. So firstly, we've got Professor Peter Bartlett, University of Nottingham. Professor Bartlett's research interests are primarily in the area of law relating to mental disability in England and Wales, but also internationally. His research interests also include the history of law and psychiatry in England, the Mental Health Act in England and Wales, the Mental Capacity Act in England and Wales, the European Convention on Human Rights, and the United Nations Convention on the Rights of Persons with Disabilities. Professor Anna Lawson is at the University of Leeds. Professor Lawson's research focuses on disability rights, equality, and human rights at the United Nations, European, and domestic levels. She's particularly interested in opportunities for change created by the UN Convention on the Rights of Persons with Disabilities, in accessibility, in reasonable accommodations and equality, in access to justice, and the disabling and enabling potential of law. So the structure for the session is that Peter will speak for 30 minutes, then we will have Anna respond for 10 minutes, and then we will have 20 minutes for questions. So I'm just going to go through the housekeeping before we get started. Regarding questions for our speakers, please post these in the Q&A box, which is at the bottom of the screen. Please also specify who your question is for, and then I will read these out anonymously so that your name won't be shared on the recording. If you're unable to type your question, then you can please just put your hand up and share the question. We will assume that you're giving your consent in the recording for your name to be shared there. But if not, just contact us afterwards and we can remove that from the recording. Now, regarding any questions you may have, please keep your questions respectful and inclusive so that we can enjoy exchanging ideas in a safe place this afternoon. Just a small comment on microphones. Please make sure that your microphones are on mute so that our speakers don't get interrupted. Again, please don't use the Zoom chat during the presentations because those using screen readers in today's session would have the chat comments interrupt the speakers. So that's really important. So any questions, Q&A box. We've got BSL interpretation today, so we have Tracy and Anne-Marie providing British Sign Language interpretation for the session. If you want to view the BSL interpretation, just click on the interpretation button, and also do reach out to Tracy or Anne-Marie by directly messaging them. Lastly, any tech issues that you may have, we have Nell on hand, so please contact her with any questions. So, without further ado, I would now like to invite our speaker, Professor Peter Bartlett, to share with us their presentation on the UN, CRPD, and neoliberalism. Peter, you have 30 minutes. Thank you. Over to you.
Thank you very much. You can hear me?
Yes.
Brilliant. First of all, my pronouns are he and him, and description of me, I'm a bespeckled white guy with a decreasing amount of rather mousy colored hair and a rather ratty beard. I hope you'll allow me to slightly abuse my position by beginning by thanking the organizers of this conference. This is the last session. That seems appropriate. It has been, I think, a really quite stimulating a couple of days. Also, apologies for the rather tedious slides. The upside is that people with difficulty seeing won't miss much. So the obvious first question is why me? I think probably the answer is I am just on the edge of publishing, has just come out a paper entitled Beyond the Liberal Subject, which seemed to match quite well, I suspect, to the organizers. The site for it is on your screen. And yes, it is open access. What I'm going to do today is give a very short sense of where that paper was going as regards the theme and rejig it a bit in terms of the themes of the conference. And since this is the last paper in the conference, I'm going to try and pull in some of the themes of the other papers that we've heard in the last couple of days. That's meant thinking about what I said in the paper through a rather different lens than it was written in, a lens of Marxism or neoliberalism. And that's been quite an interesting exercise, which I've really just started on. It also makes this paper just a touch depressing since there's been a lot discussed in the last couple of days that would affect how I think about what I wrote in the paper. That's always a good thing, though. In terms of that refocusing, just by way of not giving it false advertising, the point of that paper was to ask what the CRPD tells us about how we should be thinking about doing human rights more generally. And the argument was that the CRPD is showing us a different way of doing things that applies more generally to rights and rights agendas on behalf of what one would loosely call disadvantaged groups. In part, it was about a doctrinal analysis of the CRPD, which the argument is slightly different, and in part about how we action the CRPD. It was, however, written very much for a human rights audience, and part of that's interesting for present purposes because, of course, part of what we're doing in this conference is to challenge some of the assumptions of that discourse. Right. Many of you will know about the CRPD. We've had a couple of papers on it, including one by Jenny Logan and Lizzie Hughes yesterday. I'm not going to spend a lot of time on it, therefore. For present purposes, I think you need to know, let me remind you, it is a much more detailed convention than we're used to in human rights law. It's not just about abstract principles. It goes into considerable detail as to what is required. There's a certain element of what one might loosely call procedural surveillance. States are required to report on their progress every 4 years, and non-compliance is meant to get noticed. How successful that is, I admit, an open question. There are specific obligations to include people with lived experience and their representative organizations in all aspects of implementation. It also involves a move from rights as conceptualized as atomistic, and here we are talking about my question about moving beyond the liberal subject. Rights had, I think, been still largely articulated in a very Enlightenment context. The Enlightenment man, and I do think I mean the gendering that implies, with the social, emotional, and economic resources to press for his rights. That isn't the vision of the CRPD in quite that way. It involves an integration of civil and political along with economic and social rights. And part of the point of the paper is, the published version, is how that can be practically problematic. But the point of the CRPD is that those are really intertwined. As an obvious example, the Article 5 right to liberty is meaningful only if Article 18 rights to community living are made meaningful. A right to liberty makes no sense unless you provide another option. And it also, I argue, makes transparent a new relationship to the state. raising the question of whether we view the state as an enabler or a controller. The CRPD also is, I think, clearer than other treaties at acknowledging a move beyond the state. The recognition that much of the experience of rights, or lack of rights, happens outside of the purview of traditional government apparatus. Employment, housing, and healthcare, for at least much of the world, being particularly clear examples of that. There's a clear set of expectations that this isn't just about changing government practices, it's about changing the world. And in the paper, I talk about a good deal about how different languages of rights play out in different contexts, specifically professional contexts in the paper. And I do think if we're going to engage with implementation of rights, we are going to have to take that into account and figure out how to engage with that. We need to remember, for example, pardon me, I think a very large number of companies, and certainly a lot of those charities that Linda Steele were talking about yesterday, actually think that they're promoting rights. That suggests rather a different understanding of what all that means than what we've given. And I think if we're going to actually progress this, we need to get that on, we need to take that on board. At issue today, a few, I think, key points. First of all, is that point about the rights holder is placed in a social context. Autonomy is in a social space and actually quite a complex social space. And there are resonances here with some of the Marxist stuff that we've been hearing about. The CRPD is also interesting because in quite a brief period of time, it's gone through various forms of analysis or conceptual models. The first was, of course, the social model, where discrimination was viewed as a function of social response to difference. And we've heard a good deal about that, Mike Oliver and all that. We then get the human rights model, and I think Anna may have some things to say about how I'm carving these up, but here it goes anyway. The human rights model, which is, I think, more overt in acknowledging the lived experience of people with disabilities whose experience really is affected by impairments. It's not just for them how the world reacts, it's how they experience the world. And a focus on the persons with disabilities that comes out of that as a rights bearer. How much of a difference that makes from the social model is a really interesting question, which we might want to talk about in the chat. More recently, though, we've gotten the disability justice model, which is an implied acknowledgement that simple issues of intersectionality, as if they were ever simple, are not analytically sufficient, and we need to look at the ways in which mechanisms that oppress different marginalized groups resemble each other, and look at the synergies between those practices as they are implemented. Again, there are resonances here with some of the Marxist analyses we've heard about. Claire's raised some of this. Yeah. I would say, while we're seeing that arise in the discussions about disability and disability theory, disability studies, it hasn't yet been picked up by the CRPD committee. We'll see what happens with that. They are disability scholars. They're likely to get the point of that, but for reasons that may become clear, I'm not sure how far they're going to want to go down that route. I think the disability model is tremendously exciting on this and tremendously interesting. There is a question about how the disability justice model, fits with traditional legal models. There's a sense in some of that literature and in cognate discussions that law is the problem, not part of the solution. And we heard a certain amount of that from Agar Perez's paper in the last session, where the key strategy she identified was artistic practice, not law. So, in light of all that, how do we think about the CRPD and neoliberalism? I've got a number of points here. I'm desperately tried to put them into a coherent order, but I'm not sure I was entirely successful. If that's the case, I apologize. Let me start with a positive point. I do think the CRPD has been a significant force in changing the discourse surrounding disability and rights. By way of example, I very much enjoyed listening to Jenny and Lizzie's paper yesterday with its challenge to the use of institutions. That sort of abolitionist argument has, of course, been made for a very long time, but it has been given a new currency and a new credibility following the advent of the CRPD, specifically Article 12, Article 14, and General Comment 1. Similarly, the challenges to medicalization of disability, including psychosocial disabilities, are much more mainstream than they were when I started teaching CRIPES 35 years ago. The human potential language that Agar Perez also spoke of in the last session is at least sort of now part of that discourse. The CRPD has shifted the ground, and even for those of us that are skeptical about rights as a model and a strategy, that conceptual movement is significant. I do think that's a significant win, and we need to keep the pressure on that one. When you get to the articles themselves and the detail, you get a much more mixed picture. The CRPD is fundamentally a convention about non-discrimination based on disability. The difficulties with non-discrimination as a concept are not new in legal or political analysis. The concern, to be miserablest about it, the concern is that if we treat everybody equally badly, the world is a just place. Equally is, of course, here defined in terms of approved criteria: disability, race, sex, but as we discovered in this country a few weeks ago, not necessarily gender, are the sorts of things that make differential treatment visible in law. Other factors, talking to Marxists, most notably class, are not, even when they seem to be objectively overwhelmingly important to what's going on, they don't quite make the analytic lens. And there are obvious examples of where this sort of thing goes wrong. In the non-discrimination tradition, particularly some of the early scholars, Minkowitz being an obvious example, have spoken in favor of criminal responses for people that do criminal acts, whether they're disability related or not. That's part of the move away from understanding that, part of the move away from allowing civil detentions, and part of the movement about challenging the objective reality of disabilities that was part of that particularly early discussion. Hughes and Logan, in an early slide, remind us of the critiques of prisons and other carceral environments and suggest that that's not actually going to solve anything. I know that others of you, Linda Steele being an obvious example, have been concerned about similar issues. And that all seems to me particularly convincing given the demographics of the people who end up in prison or psych facilities. if we restrict our analysis to disability and equality, think of those with air quotes, how much will that be just a new name on the door of an institution? On this, it's worth also giving a heads up to Anna Vanya on radical racialization and disability and Roma in education. This isn't about intersectionality as we've traditionally understood it. This is about coextensive discriminatory systems. All of that raises really interesting and challenging questions about how we relate to the past. History here is an unavoidable force, and it is immoral to ignore it. And I'm thinking here of a history of oppression of Black people, women, LGBT+, people with disabilities, and lots more. But equally, the states of deprivation and marginalization by those specific groups are not unique to those groups, and they're not acceptable for anyone. In that sense, class is unavoidable in a leftist analysis, even if the neoliberals desperately want to ignore that. Most of what I've just said, we've all known for a long time. I don't have much to add to that, but it is a tension we can't sideline. And a number of the papers we've heard make that point. How much can we expect out of the CRPD on that? I think it's not yet clear. As I mentioned, the core CRPD implementation body, the CRPD committee, does seem to be firm on discrimination as the core of the CRPD, but they have in the past shifted their analytic framework from the social model to the human rights model. And they're also people with real knowledge of disabilities and disability studies, unlike, for example, usual human rights judges or usually human rights generalists with really quite minimal specific knowledge of disability. The CRPD committee will almost certainly get the point. What they do with that is much less clear. And, of course, implementation, it will be at the domestic level. In all honesty, how many of us can say that the key actors in our country really understand these issues? Would they go along with the issues if they did? For example, it's all very well for me to say that the CRPD links economic and social rights to civil and political ones, but are governments actually going to provide the civil and political rights and the social and political rights, whatever the effect? Stephen Honish's paper on means testing in Canada, Lydia Kitchen's paper on the quote, equal treatment of people with disabilities in COVID are a pretty fierce reminder of how fragile those beliefs are. And of course, I don't know how many of you are in the UK or following English political thinking, but over here we have a government that is about, once again, to cut social welfare payments to disabled people when the opposition where the opposition has been exploring exiting the ECHR for more than a decade, in part because, in their view, it already provides too much by way of social and economic rights. It's for us to do the politics on that. I can't resist adding a quick footnote to Jenny and Lizzie's paper consistent with this. The recent report on the reform of the Mental Health Act looked at community treatment orders and acknowledged that there was no evidence that they actually worked, even on the terms which they were intended to meet. They were therefore but they were not, there was no recommendation that they be taken out. They were instead put in, to use the language of the report, the last chance saloon. One wonders why. Did they believe that there's actually do good? Did they think it would scupper reform? In any event, it is not inspiring for a review that prided itself on being evidence-driven. And this is probably something we're going to be stuck with for a while. The last major reform of mental health law was about 40 years ago. It may be a long time before we see last orders in the last chance saloon. The next question I want to raise is how we think about the state. There are real ambiguities of this, I think, in the disability movement. On one hand, it's been historically an oppressor. The large-scale institutionalization of people with disabilities is the clearest, but by no means the only example. And no, that stuff hasn't stopped. At the same time, the state is viewed as necessary for key services. Some of that are services that we all depend on. Education, for a lot of us, healthcare. And some of them will be more specific to disability. For example, the financial welfare payments that are given to people with disabilities specifically. The early CRPD discourse had a bit of a sense of getting the state out. The argument was that the state cannot make good decisions on behalf of people with disabilities. And as I say, historically, there is certainly justification for that view. I trust we are all very much aware of the problems of state provision, sometimes through economic requirements imposed by limited budgets. Sometimes it needs to be said by simple callousness. But if not the state, who? A reference to the CRPD's promotion of supported decision-making yesterday rather than carceral solutions is a good example of this. By acknowledging that no one had really come up with firm and generalizable ways of doing supported decision-making. It's a good example of the problem. Who exactly is going to be providing the supported decision-making? If we believe in service provision and other forms of reasonable accommodation in the CRPD language, who other than the state is there? Linda Steele gave us an excellent paper yesterday on the problems of charitable provision in that area. In my view, she's right on pretty much everything she said. Mutual aid models were suggested, consistent with the direction, and I think that was consistent with the direction that Jenny and Lizzie were going. I appreciate the attractiveness of that sort of cooperative model, but much of what we need is going to require pretty large-scale provision. If we're to believe the sociologists, and I think on this I do, not just charities, but all organizations as they grow require the sorts of administrative structures which will lead to the problems that Linda identified. Consistent with that, remember that the people who established the charities that Linda talked about were often well-meaning people with benevolent motives. The risk, and I think it is probably inevitable, is that this sort of organization becomes an emanation of the state in effect. As an aside, one has to mention professionals. It's another universe where we can't live with them and can't really live without them. Melvin Thomas's paper is a reminder that for all their positive talk about non-discrimination and the importance of support, med school, their home turf, is not really a safe space for people with psychosocial disabilities. If not that kind of organization, well, who? Should families do more? A lot of them already do a lot. How much more should we demand? And while we will all be aware of some staggeringly good stuff that families do, we'll also be aware that they do not have an unblemished record in all cases. For those reasons, the CRPD quite properly demands safeguards. But that really pushes the problem one step forward. If we're looking at safeguards, who's actually going to provide them? The state needs to be, we need safeguards against the state as well as everything else. How exactly do we think about that? There's certainly a decay in the trust between the state as currently formed and many people with disabilities. And again, there are obvious parallels with other groups here. Women and Black people are perhaps the obvious examples. Trans people can certainly be added to that list in this country. Again, the Thomas paper is enlightening here. You see students writing about what they thought would fit the administrative model, not what was actually happening in their lives. It's hard to see that that is going to get good results. Whether the state can be reformulated into something significantly better is, in my view, at best an open question. A number of people have spoken of how institutionalization of service provision and the forcing of services into counterproductive administrative boxes. The difficulty is that's how large-scale provision works, whoever provides it. We need to find a way of engaging with that problem, and it's not clear how we do this.
Sorry, I just want to say 3 minutes.
Yep, I got
Thanks. Thank you.
Yep. Do we simply jettison rights? Lara Montesinos Coleman was unable to attend yesterday, but her paper, the abstract of her paper would suggest she thinks so. And certainly there's a long Marxist and other critical tradition to that effect. I have to say I'm more skeptical. I absolutely see the theoretical and practical limitations to rights, but if we abandon rights, the risk is we are giving an open ticket to other forms of power in society. The current international situation is providing perhaps a rather terrifying case study. The approach of the American administration to the law, about which we are so ambivalent, is exposing the really nasty effect of raw and unbridled power. While the Trump administration is particularly visible on this, similar currents can be found in all right-wing movements pretty much everywhere. These are not our friends, and the people we care about will not come out well from their interventions. While I therefore understand the skepticism about rights, this is a time when we need a united front of resistance, more, I think, than any time in my lifetime. I cannot help but feel that rights are what we've got. It would be foolish to throw them away. Thank you once again to the organizers. Thank you to you folks. I think actually I say, yes. Thank you to you folks for listening and surviving your way through this. And I look forward to your questions and comments.
Thank you ever so much, Peter, for an excellent presentation. I'd now like to invite our next speaker, Professor Anna Lawson, to respond. Anna, are you here? Ah, there you are. Wonderful to see you, Anna.
Lovely to hear you.
Okay, you have 10 minutes, and I'll hand over to you. Thank you so much.
Thank you, Emily. And I, like Peter, would like to begin by thanking the organisers. It's been a really stimulating event, and it's fascinating and really energising to hear such great debates and ideas, and chairing, I have to say, too. Thank you very much. I'm going to claim blind person's privilege and not describe myself, but Peter, I have never had a description of you before, and you have shattered my illusions. You don't look like I thought you did, so I wish I didn't know.
I'm not actually tall and blonde, sorry.
But thank you for your wonderful paper, and thank you for the article, which I've thoroughly enjoyed reading. So I am going to say 3 things. The first 2 really short, and the third one a little bit longer. First of all, in response to one thing you said, Peter, about the visibility of class, and I just wanted to say it can be visible, and it's in our power, or the legislators' power, or us in theory as people influencing them to make it visible in equality and human rights legislation. And in fact, it was Section 1 of the Equality Act is the socio-economic duty, which hasn't been brought into force yet, but it is on the agenda of this government. So let's keep fingers crossed that that does enter into force, and we do get more engagement with issues of poverty and class in our general ways of working. The second point I wanted to mention is about models. And again, I'm going to be very quick, but we could pick up on this in the debate if that's helpful. So just, sorry, my guide dog has come to say hello. On the social model and the human rights model, I think my footnote to what you said, Peter, is that two things. First of all, my sense is that the social model is a model of disability. It models disability. Disability is its subject, whereas the human rights model is really a model of disability policy, of how we go about implementing disability policy using a human rights approach. So I feel like they're doing two different things, and that certainly that the human rights model needs the social model for it to work in some ways. And I think too that impairment, although it's not, the focus of the social model is disability, it presupposes impairment and the experiences of people with impairments in interacting with the world. So I feel like there isn't so much of a difference there as maybe is sometimes thought. And certainly healthcare is something, social model proponents would very much argue for equal access to healthcare and adequate access to healthcare for disability-specific needs or impairment-specific needs. And then the disability justice model, which is very exciting and a great, very welcome source of new energy. I think, again, maybe it's not a model of disability, it's an approach to disability. But I think for me, it feels like it has a lot of synergy with the CRPD. So I think we should be careful of thinking of it as an either or. I think there's a lot in common, and it can really, there's a lot to be gained in working with them together, I think. But I take your point, Peter, about we don't know yet exactly whether there will be tensions in relation to how law works in particular, or how particular aspects of law work for the disability justice model. And I confess to I need to know more about it myself. So the last point I want to make is the longer one, and this is about picking up on your last point, Peter, about cautiousness, about throwing rights away, discarding rights in preference for other approaches or models. I think similar to debates about the social model, I sometimes feel with debates about rights that we're talking past each other, that our arguments about rights are based on different understanding of what rights are. And this really isn't surprising, because rights are contextual, both in terms of time and in terms of place, what they mean. So in the US, for instance, the CRPD hasn't been ratified. It's not, the model of rights in the US is still very much civil rights, very much negative freedoms, without the more socioeconomic second generation type of right that Peter was talking about for the CRPD. But I think we have to be careful when we're interpreting other people's critiques of rights as well, that we kind of think what types of rights are they critiquing and rejecting or approving before we jump into the debate. Peter, you very carefully situated your discussion of rights in the CRPD, which was very helpful. And that obviously is part of the international human rights system. And I just want to go back a little bit to situate that. It came out of, in 1948, after the Second World War, as we all know, and it was a response to the shock that was being experienced around the levels of abuse experienced by individuals at the hands of the state. So it was a way, individuals were at its front and centre. It was designed to protect individuals from the state. Eleanor Roosevelt, who played a lead role in those early days, the wife of the president, said in her very famous Small Places speech that it was about, the human rights venture was about bringing equal justice, equal opportunity, equal dignity to the small places close to home, where we live, the neighbourhoods we live in, the schools or colleges we attend, the places we work, the factories, farm or office where we work, were her words. Conor Gearty, who was a very famous human rights skeptic in his early academic life, has changed his mind and is a proponent of human rights and urges caution about rejecting them. He describes Human Rights Project as a visibility project, as a project that tries to get us to see outsiders, the people who are marginalised, people who are oppressed, people who we might not come across, or even if we did, might choose not to give a second glance. Very visual imagery, but we get the point. The message there is that each of us counts just because we're human. And that individual focus, I think we have to be careful. It doesn't necessarily imply an approach that regards individuals as atomistic and separate. I think, Peter, you mentioned that it requires a situated approach. It requires us to think of individuals as situated in their family, in their community, in their various contexts. And human rights needs to engage with all those contexts in order to protect the individual in the way that the Human Rights Project envisages. Legal enforcement is one means through which human rights can be enforced. But it's only one means, and it's flawed. We know the problems of access to justice. We know the problems of judicial bias. It's still an important mechanism, but it isn't perfect by any means. I think it's useful to remember that the CRPD committee can overturn, well, not, sorry, it can't overturn. It can comment on the decisions of courts, as it did in one of its early cases under the CRPD committee, sorry, under the optional protocol in Miłości and Tokarczuk versus Hungary, where it really criticised a judgment of the Supreme Court of Hungary. So it gives us a way, the mechanism of the UN human rights system gives us a way of engaging with approaches of courts, approaches of governments. And as Peter mentioned, second generation rights are really important. Sorry, Emily, I know I'm slightly running to the end. Those second generation rights, remember, include things like rights to food, water, shelter, clothing, things that are really concerned about poverty. And I think, yeah, there are, as well as individual mechanisms for enforcing human rights, there are really important collective ways of making human rights work. Eleanor Roosevelt herself stressed that. She recognised in that speech that without concerted citizen action, human rights wouldn't happen. This links to Amartya Sen's writing in 2009 in The Idea of Justice as well, where he stresses the importance of monitoring by NGOs. And the CRPD, like other human rights treaties at the UN, gives us mechanisms to do that. So it gives us the power to write shadow reports, to critique what the government is saying about how well it's done in implementing the CRPD or other human rights treaties. It also, if our countries have ratified the optional protocol, we have the potential to request inquiries into grave and systematic violations of relevant rights, as happened in the UK in relation to rights, how rights were affected by austerity. It concerns what Gerard Quinn has called a new politics. For it to work, it really needs to catalyse and engage with a new politics around human rights that's very bottom up and that engages with these mechanisms, that is about solidarity, that's about community, that isn't all about individual advancement and competition. And it gives us a way of thinking globally, a point stressed again by Amartya Sen, not just thinking about what goes on in our own country, but thinking across the world, using the same sorts of framework to organise our thinking and embedding these principles in our relations between countries. To conclude, I want to quote Connor. Oh, my niece and her friends are about to come into the room. He said, human rights should always be on the side of the underdog, perpetually trying to force an invisible individual or group of individuals into public view, giving them a language with which to shout for attention, and then, having secured it, to demand an end to suffering and a better set of life chances. In the political world we now inhabit, the human rights language, this Esperanto of the virtuous, is the best way we have worked out of securing a hearing without killing in order to do so. Thank you.
Thank you very much, Anna, for an excellent response. Yes, I've been looking at the Q&A. Could I, Peter, oh yes, I'm just trying to see so I can, oh, fantastic, I can see both of you. I must apologize also, I hope you can't hear her, but my dog has just finished her bone and decided to start barking. So yeah, if you can hear a noise in the background, I'm sorry about that. Okay, now what I'd like to do is I'd just like to remind everybody in the audience that any questions you have, if you just pop them in the Q&A box, or if you're unable to access that, just put your hand up and you can ask the question. I'll now go to some of the questions that have come in. Firstly, somebody says, thank you for your presentations. I have a question. How can we incorporate the concepts of relational, dependent, vulnerable agency into the notion of right without jettisoning the concept of right itself? This seems particularly challenging given that modern legal systems are premised on the notion of an isolated individual agent. So how can we incorporate the concepts of relational, dependent, vulnerable, and agency into the notion of right without jettisoning the concept of right? Would either of you like to take that?
Lisa, would you like to?
Sure. I think this is one of the points where the CRPD is interesting because it does actually change or challenge that discourse. So the one everyone talks about, and I think it's the right one to talk about, because it's clear, a good, clear example, is the whole question of supported decision-making. So the point of supported decision-making is you take the time to support people to reach the decision they were going to reach, that they want to reach. It is contextual, it is not atomistic in the usual sense. But the questioner is right because it gets really complicated because, of course, who's providing the support? My husband was unwell a few years ago. I was providing a lot of support and helping through those decision makings. But to pretend that I'm an uninvolved participant in that, he's my husband. Of course, I'm not an uninvolved participant. I had my views, and it's very hard to fence those out. Those tensions and the complexity of the world, if you will, the question is right. It's hard to figure out how that works. That gets much more intense as we expand the size of the pool that we're talking about here. As I mentioned, I think one of the places the CRPD does start to get it in an important way is that rights, in order to be meaningful, are not just about state practice in the sense of government. They're about everybody. How do we get everybody on board with this project? What does that look like? I'm not sure that the CRPD has a clear answer to that. I think it is the sort of question we need to be asking. And it is when we start asking about how law is going to function with that, it's going to be really quite complicated because law needs harder lines. Law needs criteria. Law needs all of that sort of stuff. So I think the CRPD is asking the right questions on that, but I don't think we've hit the point where we have answers yet.
Thank you, Peter.
Anna, over to you.
Yeah, I think I'd agree that the CRPD, that I think the model of rights envisaged in the CRPD is relational, and it does, I can't remember the other parts of the question, it does recognise dependent, I can't remember, sorry, the phrase
Yeah, do you want me
used.
to? Do you want me to repeat
Sorry,
it?
Emily.
Yeah, no, not at all. How can we incorporate
the
the concepts of relational, dependent,
yeah,
vulnerable agency into the notion of right? Yeah.
Yeah, no, I think I agree with Peter that it is very much there, but the operationalization of it requires a big change in practice. But that is the challenge of implementing the CRPD. And just to give another example to Peter's one of supported decision making, Article 19 on the right to independent living is. It's called living independently and being included in the community. That typifies that very strongly, I think. And although it's called independently, it actually is interdependently. And the guidance in the general comments go a step further than the wording of the CRPD, and they're always, particularly, I think the Article 19 general comment might be a helpful one to look at there, and the accessibility one actually. It's about requiring the state to do certain things and to, in terms of law, but also in terms of setting up regulatory systems whereby other people are responsible for monitoring progress. And yeah, I think there are lots of answers there, but they're big changes, and implementing them is going to require a change to the way of working. But that's a good thing. Yeah.
Thank you very much, Anna. So we've got 5 minutes. So there's a couple more questions. One is for Anna. It states, I'm intrigued about what you have said regarding rights. And then it says, yes, rights are individualized, but we don't have to take an atomistic approach. So the question is, could Anna please slightly expand on this? How can we avoid atomizing approaches?
Okay, thank you. I'm sure Peter could too. So I think actually, I've been working quite a lot on accessibility recently, and the CRPD recognises on the face of the treaty a right or a duty on states to ensure accessibility for the first time in an international human rights treaty. Accessibility is not an individual. It's not a right that can be imagined as an individual atomistic type of right. It necessarily involves a collective, planned, systemic approach, which once it's in place, the opportunities to participate in society, the levels of exclusion which will be experienced by many, many different disabled people will be changed. So it's something that has to be tackled at a group level, at a collective level. And that actually goes for quite a lot of the second generation rights. So the ones which progressive realization is a term that's often regarded with rightfully a degree of concern. But the good thing about it is that it requires that systemic approach to planning, putting resource, financial and human, in place to build systems which will tackle poverty, generate inclusion, and implement rights. So that's really where I'm coming from with that.
Thank you very much, Anna. Peter, did you want to add anything to that? Or
Not
It's fine.
much.
Yeah.
Again, only to really throw in,
Only because Anna said at the beginning if you wanted to. That was all.
really only our thinking on this has tended to be that everybody is pulling in the same way in terms of where they want decisions to go. I think what Anna says is right, but it becomes more complicated when people want to do things which, for cogent reasons, we think is a really bad idea. And all the rest of us get to do that. There's no reason that because you have a disability, you shouldn't be allowed to make. All of us have looked at friends and said, no, trust me, you really don't want to go out with that person. And the people go out with the person anyway. And, everybody makes these decisions, right? And just because you have a disability, you should be able to make the same bad decisions that the rest of us do. That's starting to feel much more atomistic somehow to me. That all of a sudden it is about, no, I'm cutting myself out here and I'm making my own decision. So I think the question is complex.
Thank you very much. So I'm aware of time, so I'm just going to take one last question. So this is for both of you. So it's a bit of a comment and then a question. So the point about rights being a necessary bulwark against power abuses is well made. But as both Peter and Anna have alluded to, this relies on the nation state, under monitoring from the third sector. Given transnational and globalization trends and the increasing retreat of the role of the state, both globally and domestically, what hope is there that we can rely on the state going forwards? Just a short little question there, yeah. Over to you both.
Shall I go first?
Sure, do you want to go?
Thanks,
Okay,
Anna.
Peter. Yes, what a brilliant question. I think that's one for us to take away and ponder. I honestly don't know. I think we have to keep doing what we can. As you said, civil society's engagement, what legal mechanisms we have, we need to use. And I think there's also a role in Peter mentioned, that there might be different conceptions of what rights are, and people think that they're introducing rights or working to a rights framework when actually they're not. And I think there's a role for us as well as intermediaries, as kind of explainers, or to facilitate to help communication around how you can engage with the rights system in ways that are pragmatic, that you can use it as a political tool, because that's what it is. At the end of the day, it's a political tool which we currently have, and we need to use it.
Thank you, Anna. Peter?
I think, again, the question is, does tend to go straight to the heart of everything, doesn't it? I think in the end, at least in the short to midterm, we have to back the state and try and find ways of supporting it, because the alternative is just too hideous to imagine. The question is, have we lost that battle before we start? I'm afraid, but I'm not sure I'm prepared to give up the fight. I don't think we can. If we do that, then the result really is pretty hideous to contemplate.
Thank you.
That's a cheerful thing to end on, isn't it?
Yes. Yeah, good though.
Okay, sorry, I'm going to have to bring the session to close here for now. I want to extend a huge thank you to you both. Thank you so much. We've just had Professor Peter Bartlett and Professor Anna Lawson. I also want to thank our BSL interpreters who've been working tirelessly to make these sessions accessible. Big thank you to our tech support and also to the organising committee for enabling this conference to happen. So this is the end of our last keynote for the conference. I'll now hand over to Claire Williams for the closing remarks on the conference. Thank you very much.
Thank
Over
you
to you,
so much.
Claire.
Thanks so much, Emily. What a fantastic session to end with, and so many questions left pending. I'm going to keep an eye on time and make sure that we finish on the dot of 2:30, if not slightly beforehand. And I would also like to thank all our speakers over the last 2 days for such rich and really thought-provoking discussions, and also to Peter for kind of doing my job for me and offering such an insightful summary of the past 2 days, and to Anna for such an excellent response there. Now, these 2 days have been a real treat for me personally, as someone who is slightly skeptically working on the role of rights in realising disability equity and justice. I hope these sessions have been as generative for you all as well. As I mentioned in my opening remarks yesterday, this event was prompted by a curiosity about what rights have actually achieved for disabled people and what their potential really is for realising full substantive equality and inclusion and ending ongoing oppression. And to that end, I found it really striking that so many of our speakers also mentioned the wins that the disability rights movement has seen, and that there's potential here, despite how problematic rights discourses can be. And Peter rightly reminds us of the importance of pinning down language between groups, between communities, and the concepts and the conceptions that we're working with. I'm sure you've all spotted some emerging themes from our panels and keynotes. For me, some of the standout themes that have begun to emerge include the ways in which the use of rights discourses and language have had the effect of advancing processes and structures of neoliberalism, whether this is through the rebranding of charities or through the legal fights of trades unions, challenges to segregated education, and so on, that have in fact seen a retrenchment of carceral and disciplinary techniques of governance. And then also the ways in which the law, whilst we might recognise it as harmful in some senses, remains the predominant channel through which challenges to oppression must seemingly be officially mounted, either through legal mechanisms or through the use of rights-based discourses and juridical forms or arguments to bring this veneer of mainstream normality. In other words, so we recognise the harm that these approaches perpetuate, but the challenges still seem to feel the need to make use of these approaches that reify the state and the power of the law, and that inherently reproduce neoliberal logics in the process. And then throughout several of the papers that we've heard, we've seen the translation of political concerns into juridical arguments. And I was struck by Anna's comment just now that rights are political tools. But this conversion into legal arguments, forcing the oppressed party or the disadvantaged group or their interlocutors to normalize themselves to be able to construct arguments. And at the same time, our first panel this morning explored the limitations of the language that we used and the way that our language, or the euphemisms that we default to normalize discourse, both reveals and conceals, just like the law. And that to mount effective challenges to oppression under neoliberalism, we need to really pay attention to what our language is concealing, not only when we contest disadvantage, but when we rationalize our own experiences of quote unquote wellness and its dialectical inverse to ourselves. But there are some alternatives, some really exciting alternatives that began to emerge, from a repair or reparation framework to the potential of grassroots movements to challenging ongoing inequalities and disadvantage from below, whilst also potentially continuing with rights-based claims to challenge from above, to approaches based in the pragmatist tradition. This is all in the context of needing to look beyond NGOs for effective resistance, raising the question of the extent to which strategies are, or should be, or need to remain contextually contingent to be most effective. And I'm really curious to think through how we can tease out those contingencies to properly understand how resistance to processes of disablement under neoliberalism can be realized without sole recourse to rights-based narratives. And then what came through really clearly for me over the past couple of days was the value of bringing people together, working on disability, political economy and law and sociology and many, many more, to generate a truly interdisciplinary conversation on the role of rights. As a lawyer, I found this really refreshing and really generative, and the insights that have begun to emerge are really valuable for my own work. And I'm looking forward to seeing how these conversations develop over the coming months. So to go back to the original question then, what role for rights? Should we put up with the structural, institutional, affective and epistemic violence that rights-based discourses perpetuate because of their potential? And to go back to Peter's point here, if we think about law as the language of power, and that's power that can be co-opted and subverted, as we are seeing in real time play out on the news every night, taking away or dispensing with rights can just leave a vacuum into which other forms of power can insert themselves. Or should we be reorienting resistance to evaluate the role of rights, embedding them as but one response to the oppressions of neoliberalism? Now, as I've mentioned, or at least as I hope I've mentioned, we're currently thinking through ways to take forward the conversations that we've started here over the last couple of days, and to develop some of the synergies and lessons that have begun to emerge. And to that end, please do stay tuned for updates. Now, you can do this by joining the Marxism and Disability Network and the SLSA, the Socio-Legal Studies Association, for updates, as well as to receive notifications of when recordings of these sessions and blog posts are posted online. There are links to join both in the confirmation emails that you've received about this event. Now, the Marxism and Disability Network holds monthly, shameless plug coming up, forgive me. The Marxism and Disability Network holds monthly talks on disability and disability theory through a Marxist lens. Luke's already mentioned one of them in an earlier session today, with the recordings of those being posted to the Historical Materialism YouTube channel. And the MDN is also hosting a stream at Historical Materialism's conference in November this year at SOAS in London. So please do check that out. The SLSA, the Socio-Legal Studies Association, holds its big annual conference every year, but each conference stream, and so we are the Disability Law and Social Justice conference stream, but conference streams host ongoing activities and events throughout the year, as well as ad hoc events that the SLSA offers funding for. So please do consider joining up. There are heavily discounted rates for PGR students as well. So finally, I would like to extend a huge thank you once again to all our speakers over the past couple of days, and a reminder that you can access their slides, which they very kindly shared via the Google Drive, which is also linked in your confirmation email if you'd like to know more. I'd also like to thank, just as Emily has done, I'd like to echo her thanks to our wonderful BSL interpreters, Anne-Marie and Tracy, for their work over the past couple of days, their patience with us, and for making this event accessible. And a huge thank you to Nell and to Steve, our tech support experts, for making this event run so smoothly. A last thanks once again goes to our funders, the SLSA and the University of Leicester Law School, as well as to support from the Universities of Birmingham and Brighton for making this event possible, and also to colleagues and the organising committee from the SLSA and MDN for making this happen. It's been an absolute joy working with you all. And then, of course, finally, thank you all for joining us over the last couple of days and making this such an enjoyable and generative experience. So take care of yourselves. Please join the mailing lists, stay tuned, and we look forward to seeing you all again soon. Thank you very much.